Hello, YouTubers, and welcome to Level-Headed News. This is your host, Brenda. I have 9 articles for you in this episode. I think you'll enjoy this one. First article that I have here is off of OregonLive.com, and all these URLs, of course, are in the description of the video for your convenience if you want to check out anything with them. It would be a good one because anybody that's been following the Bundy trials going on in Oregon and in Nevada, you might find this of some interest. This says Chief Federal Judge moves to prevent Marcus Mumford from practicing in federal court in Oregon. And if you've been keeping up with this, you know Mumford was one of the lawyers involved in the Oregon. Well, here's what it says. Attorney Marcus Mumford, who last month had criminal charges dismissed against him stemming from his arrest on the day his client Ammon Bundy was acquitted of conspiracy in federal court in Portland, now faces more legal challenges. Oregon's Chief U.S. District Judge Michael W. Mossman is seeking to revoke Mumford's ability to practice law in any federal court in the District of Oregon, a rare move. The judge has given Mumford until May the 4th to argue in writing why he should not impose such a sanction. In a court filing on Wednesday, Mossman cited Mumford's repeated failures or refusals to observe court rulings in the Bundy trial last fall, repeated instances of Mumford's arguing with the judge, voice, and sometimes in the jury's presence, inappropriate commentary on a witness in the presence of the jury, his arguing for Bundy's release from the trial after his acquittal without basis to believe that the pre-existing custody order from Nevada was not still in effect, and his yelling at the court when he objected to the trial judge's rulings. Transferred to Nevada jail after his acquittal in Oregon. He awaits trial there on federal charges stemming from the 2014 armed standoff with federal land officers near his father Cliven Bundy's ranch in Bunkerville, Nevada. Mossman also alleged that Mumford failed to timely disclose to the trial judge that who served as part of Bundy's defense team was also a client of Mumford's in an unrelated criminal proceeding. In 2014, a federal judge in Utah tossed out 18 charges against Kober that had alleged he operated a giant Ponzi scheme company, but Kober was recently re-indicted on 18 charges in January. 25 exhibits with his order, mostly transcripts from Bundy's trial, to support his move to revoke Mumford's admission to practice in federal court in Oregon. My initial reaction is the Empire Strikes Back, Mumford said in an email Wednesday. I know of no court order that I violated and no reason to impose some kind of lifetime ban to practice law in Oregon. I was arrested on the last day of Bundy's trial after verdicts were announced in court. Tackled Mumford to the floor, stunned him with a taser gun, and arrested him after he had repeatedly questioned the court about what authority the marshals had to keep Bundy in custody after his acquittal in the federal conspiracy case stemming from armed takeover in the Malheur National Wildlife Refuge, with failing to comply with official signs that prohibit the disruption of federal officers' official work and failing to comply with a federal officer's direction to stop resisting and to place his hands behind his back. The trial had the 13th. Mumford's lawyer, Michael Levine, had argued repeatedly that the deputy U.S. Marshals engaged in outrageous misconduct and requested any emails or text messages between marshals about Mumford as part of discovery in preparation for trial. In mid-March, a specially judge from Washington dismissed all criminal charges against Mumford at the prosecution's request. Mumford also came under scrutiny during a 5-week trial in U.S. District Judge Anna J. Brown's court. During trial, she had threatened to fine Mumford court, but never followed through. Brown's admonition to Mumford in late September came after she said Mumford appeared to be defying her order not to delve into circumstances surrounding the police's or the police fatal shooting of refuge occupation spokesman Robert Lavoy Finicum. Brown also had repeatedly ordered Mumford during the trial to restrict his questions during cross-examination to testimony during prosecutors' direct examination of witnesses. The trial judge also frequently sustained objections to Mumford's lines of questioning because they were either irrelevant or beyond the scope of testimony. If Mosman does revoke Mumford's ability to practice in any Oregon federal court, the judge will dissolve the sanction bar under which Mumford currently practices law, and Mumford will be required to disclose such a sanction when applying to practice in any federal court in the future. For Judge Mosman to be the one who issues this order, especially disappointing because I specifically asked him to intercede on my behalf as voice of reason in dealing with the marshal's misbegotten prosecution, but the responded to say that he was recusing himself. It's as if he's now saying his recusals are selective, Mumford wrote in his email. I don't know. It sounds to me like if I was on trial, that's the kind of dude that I'd want representing me. You know, it is what it is. We'll have to keep an eye on that and see what happens. Next one here is off of BizPac Review. Marvel vows disciplinary action for Muslim X-Men comic over secret anti-Christian, anti-Jewish messages. Marvel Comics announced it will be taking disciplinary action against Indonesian artist Saif regarding the controversial first issue of X-Men Gold. Saif inserted coded anti-Christian, anti-Jewish messages that center around the number 212 and 51 in the artwork symbols to current religious and political issues happening in Indonesia, the Jakarta Post reported. There's some tweets here that show what they're talking about if you want to pull that up. The symbols reference the protest against Jakarta Governor Basuki Huk Tajhaja Purnama, the Post reported. More from the Post here says, in one of the panels showing a baseball match between the new members of the X-Men QS5 :51 is written on Colossu's shirt. Another panel shows the numbers 212 above a building near two X-Men. Leader Kitty Pryde's head, one of the most prominent Jewish heroes in Marvel Comics, according to io9.gizmodo. QS5 :51 is allegedly a reference to the Surah al-Mahada, verse 51 of the Quran. Huk, a Christian and Chinese Indonesian operating in a Muslim majority country, angered Muslim groups after he referenced the verse during a visit to Thousand Islands Regency on September 27th of 2016. In response to a growing outcry, Marvel released a statement on Saturday saying the mentioned artwork in the X-Men Gold #1 was asserted without the knowledge behind its reported meanings, the statement said. These implied references do not reflect the views of the writer, editors, or anyone else at Marvel, and are in direct opposition of the inclusiveness of Marvel Comics and what the X-Men have stood for since their creation. This artwork will be removed from subsequent printings, digital versions, and trade paperbacks, and disciplinary action is being taken. Following Marvel's announcement, Saif took to Facebook to essentially say his career is finished. And there is an insert here where I guess it was supposed to be his Facebook post, but it says this Facebook post is no longer available. It may have been removed, or the privacy settings of the post may have been changed. Interesting. So the next one here is off of Liberty Headlines, and it says Texas student commits suicide after Title IX kangaroo court. Other egregious sample of a male student denied due process after being accused of sexual misconduct gets ignored. This one should not be. who was accused of sexual harassment, committed suicide just days after the University of Texas at Arlington ignored its own policies in order to punish him. Student's father, a lawyer acting as the administrator of his son's estate, is now suing the school for violating his son's Title IX rights. College administrators, as well as members of the media and legislators, would do well to remember the name Thomas Clock. Clock, a straight male, was accused by a gay male student of writing anti-gay slurs on his computer during a class. Clock vehemently denied the accusation, and administrators who investigated the incident acknowledged there was no evidence to support the accuser's claims, yet Clock was still punished. The accusing student, who is being sued by Clock's father for defamation, claims that in May of 2016, Clock made a comment during a class about privilege and then proceeded to open his laptop and type "gays should die" into his web browser search bar. The accuser, who is not being named because Watchdog was unable to contact him for comment, claims he typed into his own browser search bar, "I'm gay." The accuser next claimed that Clock feigned a yawn and said under his breath, "Well, then you're a faggot." The accuser says he told Clock he should leave the class, to which Clock allegedly responded, "You should consider killing yourself." The accuser claims he was made so uncomfortable by the exchange that he waited until the end of class and spoke to the professor, who allegedly told him to contact student support services. There is no documentation to suggest the professor was interviewed in the course of the investigation in order to corroborate the accuser's claims. The attorney for Clock's father, Kenneth Chaikin, told Watchdog the professor never provided a witness statement, suggesting he was never asked what he saw that day. Clock insisted that what happened in mid-May class in 2016 was completely different than what the accuser claimed. Clock said his accuser made unwelcome sexual advances toward him. Clock rejected the advances, telling his eventual accuser that he was straight. The lawsuit suggests that this rejection led the accuser to make up his story, possibly out of fear that he himself could be accused of sexual misconduct. Instead of seeking support services, the accuser reached out to Associate Vice President of Student Affairs Heather Snow, with whom he had a friendly relationship. The accuser was close enough to Snow to refer her by her first name at times, and Stowe quickly became the accuser's advocate, helping him to draft a complaint against Clock and conducting the disciplinary procedure without following the school's Title IX policies. The lawsuit alleges that UTA's Title IX coordinator was not informed of the allegation, even though Snow suggested it constituted sexual harassment. This is a violation of UTA's policies regarding sexual misconduct, which state complaints should be made to the Title IX coordinator or deputy coordinator. Snow was neither. Further, UTA's Title IX policies state that the Title IX coordinator is responsible for overseeing the investigation and assigning an investigator. The investigator must then produce a report based on facts gathered and present it to the Title IX coordinator and deputy coordinator before any hearing. Clock received no hearing, even though he contradicted his accuser's claims. Had Snow properly reported the complaint to Title IX coordinator, Clock would have received necessary protections from the school. By doing things on her own terms, Snow was able to deny Clock his rights to state as stated in UTA policy. Snow took control of the disciplinary procedure that involved a complainant she wrote herself, or a complaint she wrote herself. She enlisted the help of UTA's Associate Director of Academic Integrity, Daniel Moore, and had him tell Clock he was immediately prohibited from attending the class where the incident was alleged to have occurred. Clock was completing the course as part of a short pre-summer semester in order to graduate that summer. When Clock was informed that an accusation had been lodged against him, he was not told the name of his accuser. Clock was also informed that he could not contact anyone in the class, directly or indirectly, effectively denying him any ability to find witnesses to corroborate his story. The accuser was able to remain in the class He found only one who didn't corroborate his account, but did say he overheard someone say, "You should leave." This could have been said by either Clark or his accuser in either case of their stories. Clark told Moore he needed to attend the class and asked for more information about the accusation against him. Moore ignored his request but sent Clark a summons letter on May the 20th. The lawsuit alleges Moore never informed Clark that this was Title IX investigation, as Moore usually handled academic issues, or Clark's rights under the Title IX. Moore also never told Clark that he would not be allowed a hearing. He was never informed that Snow, who was not an impartial party, was running the show, even helping Moore determine a punishment. Clark was charged with violating Title IX based solely on the accusation. He was charged with 2 violations: physical abuse or threat thereof, and non-specific violation of the school's anti-harassment policy. It should be noted that the accuser never claimed Clark was physical or threatened physical harm. But charging Clark in this manner, UTA further violated its own policies, which state that charges are supposed to come after an investigation and hearing, and after the accused had a chance to present witnesses in his defense. The accuser's report, written in whole or part by Snow, was described as a statement of evidence against Clark. Clark was not provided a list of witnesses, even though Moore's summons letter said he would do so. Moore's letter informed Clark that he could be expelled over the accusation, though UTA policy states that accused students facing such punishment have the right to a hearing, which Clark was denied. Clark met with Moore on May the 23rd of 2016. Clark brought his father, Wayne, an attorney, but was told Wayne could not stay. Moore did not tell Clark that his father would be allowed to stay if Clark waived confidentiality. Wayne's attorney deposed Snow and Moore ahead of filing the lawsuit and received documents from UTA regarding Clark's case. Notes from Moore's meeting with Clark indicated the accused student said he didn't know the name of his accuser prior to the incident and wondered how the accuser knew his name. Clark also told his side of the story, claiming his accuser sat next to him that day in class and called Clark beautiful. Clark said he typed into his browser, "Stop, I'm straight," to which his accuser replied, "I'm gay." Clark further said his accuser kept glancing at him, so he asked him to stop. He denied faking a yawn and said he was the one who asked his accuser to leave. His accuser began typing on his phone and laughing, which Clark found distracting, so he moved across the room to about 30 to 45 minutes into the class. Clark denied typing any slurs into his web browser. Despite learning that Clark may have been the victim of sexual harassment, no investigation was conducted, and Clark was not told he should file a report. After the meeting, Moore informed Clark that he needed to go to a private room to take an exam for the class he was not allowed to attend. Since Clark had not been allowed to attend the class in the prior days, he was unaware of some of the test material and thus did poorly. Moore also told Clark he could continue working outside of class but couldn't attend the class itself. Moore informed Clark that he would be speaking to a witness and would decide Clark's fate after. UTA Policy 9 states that disputed accusations and charges that could result in expulsion shall include a hearing. Again, Clark was denied this. On May the 24th of 2016, Moore and Snow discussed the case. Snow asked if Clark acknowledged the behavior he was accused of, to which Moore replied, "Not at all." He told Snow the student had completely different accounts of the incident in question, but did not tell Snow what Clark's story was. Moore also told Snow he didn't have enough evidence to keep Clark out of class. Snow agreed, saying there isn't enough to go off of, and said Clark should be allowed to be back in the class with mutual non-contact order with his accuser. Instead, Moore said he would look for another way to keep Clark out of the class, and Snow told him to see if the class would be offered later in the summer. This, the lawsuit states, effectively confirmed that Thomas not only should remain excluded from the classroom, but that he should be excluded from the course altogether, despite the fact that there was not enough to go off of to keep Thomas out of the classroom. Moore reported back to Snow that he worked it out to keep Clock out of the class. Snow said it seemed like a good resolution. Moore sent Clock a letter the next day on May the 25th, stating that Clock had been found responsible of harassment, even though Moore and Snow acknowledged there was no evidence to support this claim. Clock was placed on disciplinary probation for the remainder of his time at UTA and would have this on his disciplinary record. It was never explained to Clock why he was found responsible when there was no evidence. Chaikin, the filing attorney, told Watchdog that someone informed Clock that this disciplinary record could keep him out of grad school, which Clock had planned to attend after graduation in the summer. Just days after Clock was punished, he took his own life. Had Snow and Moore followed proper UTA policy, Clock might never have been punished in the first place, as he would have been allowed a hearing to present evidence in his defense. Clock's father alleges his son was discriminated against because he was a male accused student, and that Snow and Moore selectively enforced UTA's Title IX procedures. Clock had no prior history of mental health problems and by all accounts was happy and looking forward to the future after graduation. In a statement to Watchdog, Chaikin expressed the importance of a fair investigation. When a college violates legal rights of a student accused of misconduct and its own rules for addressing such a complaint, the accused student can suffer life-altering consequences, he said in an email. The important case of Clock versus University of Texas at Arlington illustrates just how quickly and arbitrarily a college can act, leading to most tragic outcome from unimaginable stress and pain that an unfairly treated accused student can suffer. It also serves as an underscore why reforms in the campus disciplinary process are so necessary, as recently recommended by the American College of Trial Lawyers, and why accountability through the judicial process may help to promote those reforms. Representatives for UTA did not respond to a Watchdog request for comment. I mean, there's a lot of lessons there. A lot of lessons in that one. Things that you do to other people, while it may not seem like a big deal to you, might be life-altering to them. So watch what you do to people. And on the other side of the coin, don't do something drastic for a temporary problem. I mean, yeah, it might seem like it's an awful big load, but this too shall pass, you know. But once your life is gone, you don't have a chance to correct anything. Wow. Next article is off of IN.com. And this one says, explosion at ammunition plant kills 1 and injures 4. Other explosions have occurred at the Midwestern plant, including a 1990 blast that killed 1 worker and a 1981 explosion that severely burned a worker who later died. This is out of Kansas City, Missouri. It says an explosion Tuesday at a sprawling ammunition plant near Kansas City, Missouri, killed 1 worker and injured 4 others. In the U.S. Army said. The blast at the Lake City Army ammunition plant in Independence, just east of Kansas City, occurred in a building where chemicals are mixed, Army officials said. The building has been secured and rendered safe, they said, allowing investigators to begin looking into what caused the explosion. Other explosions have occurred at the plant, including a 1990 blast that killed 1 worker and a 1981 explosion that severely burned a worker who later died, according to records. In 2011, 6 people were injured in a blast there. The plant has been fined for workplace safety issues at least 3 times. All the plants nearby, 1,800 employees, were sent home after Tuesday's explosion and told to call in before returning to work Wednesday. The 4 injured workers were evaluated at the scene and declined additional treatment, officials said. Lieutenant Colonel Eric B. Dennis, the plant's commander, offered his condolences to family members of the workers who died. Making ammunition is dangerous work, and our employees risk their lives to protect the men and women in uniform, Dennis said. This is the sacrifice they make to support our country, and I am humbled by the ultimate sacrifice this employee made today. The Bureau of Alcohol, Tobacco, and Firearms and Explosives will lead the investigation. Workplace safety experts with the U.S. Department of Labor's Occupational Safety and Health Administration will also be looking into the blast. The 77-year-old plant, created to help arm the U.S. military effort in the run-up to World War II, makes small caliber ammunition and tests its reliability. The factory also operates the NATO Test Center. The plant, which sits on nearly 4,000 acres, and is the first of a dozen Army small arms factories, has undergone hundreds of millions of dollars in upgrades since the midst of 2000s. The property has more than 400 buildings and 9 warehouses and has storage capacity of more than 700,000 square feet. The factory has a governmental staff payroll of $2.9 million and a workforce that includes 29 Department of Army civilians and a soldier to provide contract oversight. Dual's Virginia-based contractor Orbital ATK, the biggest maker of small caliber ammunition for U.S. Department of Defense, runs the plant. Since 2000, Orbital has produced more than 17 billion rounds of small caliber ammunition at Lake City for military purposes. John Nichols, Vice President and General Manager of Orbital ATK, said the explosion happened in a building where workers mixed chemicals into the primer that goes into all small caliber munitions. Orbital announced Monday that it has received $92 million order from the Army for 5.56 millimeter and 7.62 millimeter ammunition, adding that Orbital and the Army have made significant upgrades at the facility in recent years that have enhanced product quality and performance, efficiency, and operational improvements and safety, or for safety and environmental stewardship. Orbital has roughly 12,500 employees in 18 states and in several international locations. When the 2011 explosion occurred at the plant, injuring 6 people, Alliant Tech Systems, or ATK, was the contractor operating the facility. OSHA fined the plant for workplace safety issues that year and also in 2008 and 2012. The largest penalty was in 2011 when Alliant was initially fined $28,000. It paid $5,600. OSHA had cited it for serious issues with process safety management of hazardous chemicals. The next article that I have for you is off of, and it says, read before flying, Delta's new gun policy. Delta Airlines has new gun policy requiring guns checked in as baggage to be picked up at the baggage service office when you arrive. Delta stated, Delta is committed to safety of our customers and employees. Every day we look for ways to refine process and procedures with goals to improve safety and the overall travel experience. This comes in response to realizing the vulnerabilities of soft target areas after the Fort Lauderdale Hollywood International Airport shooting. The incident also highlighted the fact that passengers can legally pack guns in checked baggage and access them after claiming their bag. The FBI said Esteban Santiago flew on a one-way ticket from Alaska to Fort Lauderdale with a gun and ammunition in a case checked luggage, according to the Associated Press. Authorities say he picked up the case, loaded the gun in the bathroom, and came out firing at travelers for increased security to prevent such incidents at airports. Delta's policy on shooting equipment also says, until further advised, passengers deporting Brussels, Belgium, are not allowed to check weapons, including antique, sporting, hunting, or toy rifles, in their checked baggage. It sounds like they are simply trying to make things safer and not coming down on the gun community. The next article is off of BizPack Review. And it says, volunteer Easter egg hunt gets canceled and the reason is going to infuriate you. The Volunteer Fire Company from Pennsylvania has announced it is canceling its long-held free Easter egg hunt for local kids because firemen are sick and tired of the parents being so unruly and ruining the kids' fun. The Norco Fire Company in North Coventry Township took to its Facebook page to announce the cancellation of the annual event, the New York Post reported. We have received numerous messages regarding our annual Easter egg hunt. Unfortunately, due to the past year's unruly crowds, we will not be having the egg hunt this year. We know that the majority of our community is not the problem, but we can't risk injury of children because certain individuals can't control themselves. We're hoping to try again at some point. Thank you for your continued support of Norco Fire Company. Deputy Chief Chuck Hipple said they have been putting up with over-competitive and unruly parents for years and that the behavior poses a risk to other kids. Hipple added that it's not a majority of parents, but a few just can't seem to let the kids have fun. Numerous complaints appeared on the fire company's Facebook page accusing them of making up and exaggerating allegations against parents. All complaints were dealt with politely and given an application to volunteer. This whole incident is similar to the over-competitive parents often seen in kids' sports. How many stories have we seen of parents that don't know how to conduct themselves, getting thrown out of games or even arrested for their obscene behavior? Just last year, one Little League team had to erect a sign to remind parents to stop taking their kids' games so seriously and just relax. The sign reminded parents that it's just a game and the officials are humans. It's all just more evidence that our society is losing its grip on good behavior. What is heartbreaking is that all this nonsense is ruining our kids' childhoods. The next article is off of Liberty Headlines. It says, college students fear Chick-fil-A as a threat to safety. Student senators at Wentz University are lobbying for the cancellation of plans to bring a Chick-fil-A to campus in the fall, saying they fear for the safety of their peers. The popular fast food chain came under fire in 2012 after its president, Dun Cathy, admitted his company was guilty as charged for donating to organizations opposed to same-sex marriage, prompting years of protests by LGBT activists, especially on college campuses. I fear that with Chick-fil-A being in options, that many people will feel that safe place is a risk. Campus Reform reported in 2015, for instance, that the Student Government Association at Johns Hopkins University demanded the removal of Chick-fil-A from campus, calling its presence a microaggression. Though outrage slowly died down as IRS filings showed the company had virtually canceled its donations to organizations opposing same-sex marriage. Now, however, Weston University student Senator Nico Martini has reignited concerns over the company's past by proposing a resolution at the Student Government Association's SGA March 26th meeting to nix the restaurant from a list of proposed overhauls to the school's dining options. Chick-fil-A has questionable history on civil rights and human rights. Martini remarked in a statement to the Duke that the university chooses to do business with organizations that coincide with the university's mission and expectations they give students regarding diversity and inclusion. Holy smoke. There's a whole lot of young people need to grow up. Wow. If you don't approve of what they're standing for, then don't buy their product. That's all you got to do. If enough people don't buy their product, they won't be there. Don't they teach them that in economics class? Apparently not. They're too busy coloring. Next article is off of Breitbart. It says, study, unemployment makes men unattractive and crazy. Now, here's a lesson for you fellers that ain't got a job. I'll tell you what. It says, job losses are more than just an economic drag. They are literally depressing. New research shows that severe depressive symptoms are partly a consequence of the loss of employment and subsequent economic inactivity. The longer the period of unemployment, the greater incidence of depression, according to a study of Australian labour market data by Deborah A. Cobb-Clark School of the University of Sydney. Cobb-Clark's study shows that joblessness weighs on men more than women. Men's mental health starts to deteriorate as soon as they exit the labor market. Women are apparently made of sterner stuff. Their mental health only worsens after they've been out of the labor force for a period of time. Unemployment can lead to self-perpetuating downward spiral. The research also finds that severe depressive symptoms lead to economic inactivity. Individuals are less likely to employed if they experience severe depressive symptoms. Men's probability of being unemployed rises dramatically with the onset of depressive symptoms. Women's unemployment is increased by protracted depressive symptoms, Cobb-Clark writes. In other words, unemployment leads to depression and depression leads to unemployment. This may offer a possible hint to the findings of a separate investigation recently undertaken by researchers at Federal Reserve Bank of New York, analyzing consumer survey data collected by the Fed over the last few years. The research found that it is far harder to get a job when you are unemployed than when you are employed. Even though unemployed workers search about 7 times as hard as the employed, they only generate about twice the number of offers. Thus, searching while unemployed is much less effective in generating offers than searching while on the job, they write. Of course, if the job searchers are suffering from depression and other signs of deteriorating mental health, it would make sense that employers are less likely to hire them. Compared to their employed peers, the unemployed would simply be hires. And of course, it's probably harder for unemployed men to find romantic success, since 1 in 5 women say they won't date a man who earns less than they do. So an unemployed man would be unattractive to both potential employers and mates. No wonder that is depressing. The next article should be in the category I cannot make this stuff up. It's off Breitbart, and it says, condom clogged pipe triggers Texas brothel bust. Police officers discovered a prostitution ring in a massage parlor after a sewer line became clogged with condoms. The massage parlor in Northwest Austin was discovered to be a prostitution ring after a sewer pipe at the business was destroyed by hundreds of condoms, according to the Austin American-Statesman. A reality company, reality, okay, yeah, I bet it's reality. A realty company had recently taken over the property, located in a shopping center where the prostitution ring was doing business as at Massage Therapy LLC. Police were tipped off about the prostitution ring in early February when, according to an affidavit, several tenants became worried that illicit activities were occurring after an industrial disposal unit connected to the city's sewer line was clogged with hundreds of condoms. The clogged line was not the only piece of evidence that led investigators to uncovering the ring allegedly owned by a woman named Wang and her husband, Joseph Emery. Oh, I cannot make this stuff up. 2 days prior to receiving the tip, Wang was reportedly stopped by security at Austin Bergstrom International Airport after she was discovered carrying $30,000 in cash. Wang reportedly told police that the money was for a medical procedure she had been saving for in China. Wang allegedly claimed that she only makes $20,000 a year at Jade Massage. When the police pointed out to her that she was carrying 18 months of income, she reportedly became this. She gave the police a contact phone number to reach her at and then boarded her flight to China. When police investigated the phone number, they reportedly discovered it was linked to a Backpage.com account that had advertisements for sexual services at her business. Police were able to obtain a search warrant based off the evidence gathered and executed it on March the 22nd. Investigators found reportedly Wang with a naked man and another nude couple in a separate room. They also found more than $65,000 in a safe at Wang and Emery's home, according to the local paper. Investigators claimed that 12 women worked at Jade Massage, lived with Wang and Emery at their home. Police found records of the names with hundreds of receipts with excessive tips paid. Wang and Emery have not yet been placed in custody as of Tuesday, but they face charges of engaging in organized criminal activity and money laundering. Can't make this stuff up. If you like what I'm doing here, give it a thumbs up, share it on your social media so everybody gets to be entertained, and don't forget to subscribe. That way you'll stay informed. Have a great day.